Hey there, thanks for tuning into the Freedom Update. Today I want to tell you about a recent decision from the Supreme Court of Canada dealing with freedom of expression and comedy. It's a case that we were involved in at the Canadian Constitution Foundation, and I'm really happy to say that it's a case that went exactly the way we wanted it to go. If you're new here, welcome. My name is Christine Van Gyn, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about updates on our ongoing cases and other interesting stories about constitutional law in Canada. If that sounds like something you might be interested in, please hit like and subscribe below. It really helps my videos out a lot. And as always, please remember that my videos are for information purposes only. They are not legal advice. If you have your own legal problem or question, please consult your own lawyer who can help you with your individual circumstances. So I've been trying to make these video updates a little bit more regular, and it definitely helps when I have an update about a case like the one I have today. I make and edit these videos myself, and I actually usually do them on Fridays after a full day of filming my television program, Canadian Justice. If you're interested in the program, you can watch it on Bell or Rogers, or you can watch it on the News Forum Facebook page or YouTube channel. I'll put a link below. Anyway, I do edit these videos myself, which is a lot of work to create the content and edit it. And oh man, last week someone pointed out that I had a typo in one of my graphics, and it just completely kills me when something like that happens. So please don't judge me if I have a little error like that. It happens to the best of us, so I hope you forgive me for that. But if you do see an error or want to make a comment, please feel free to leave the comment below in the section below, or you can also always reach out to me by email. You can reach me at cvangyn@theccf.ca. My email is and has always been publicly listed, so feel free to reach out. Okay, so now on to the case, which is called Ward and the Quebec Human Rights Commission. The case involves a Quebec comedian named Mike Ward and a child with a disability named Jeremy Gabriel. Or at least he was a child at the time. He's an adult now. He was a child when the case was initiated about 10 years ago. Mr. Ward is a fairly famous Quebec comedian who specializes in what's called dark comedy. And Mr. Gabriel is an also somewhat famous, at the time, teenage boy who was born with a disability called Treacher-Collins syndrome, which caused some facial deformities as well as profound deafness. Mr. Gabriel, as a child, received a bone-implanted hearing aid, which allowed him to hear and also to sing. And he started a singing career and became somewhat of a local Quebec celebrity himself. He performed at sports games, he sang for Celine Dion, he sang for the Pope, so he was also quite well known in Quebec. Between 2010 and 2013, Mr. Ward told a series of jokes at his stand-up shows about what he called the sacred cows of Quebec. People who were too famous, rich, powerful, or special to be joked about. One of the reasons he wanted to do this type of routine is that Mr. Ward said it had become impossible in Quebec to mock people without risking legal proceedings. And it seems like he was right. So in his routine, Mr. Ward told jokes about many famous Quebecers, including about Mr. Gabriel. And these included jokes about Mr. Gabriel's appearance, about his disability, about his singing talent, and he even joked about drowning Mr. Gabriel, who I have to say was a child at the time. This is pretty rough stuff, and I won't repeat the jokes themselves since I'm not a comic, and they definitely won't be funny in the context of a YouTube legal analysis. But I will say that the audiences did laugh at the joke, as audiences do, especially when they're there to see a show by a comedian who specializes in dark comedy. You know, these are audiences who are there to be shocked. I'll say right now, off the bat, that I think the idea of making jokes about a disabled child is pretty distasteful, and targeting a specific individual child is especially cruel. Mr. Gabriel has said that these jokes caused him to be terribly bullied at school, and he said they caused him to even have suicidal thoughts. This is just terrible. And I'm so sorry to Mr. Gabriel that he had this happen. He sounds like a really inspiring person, and I want good things for him. I also don't doubt that Mr. Gabriel was hurt. And because of this hurt, he and his mother made a complaint to the Quebec Human Rights Commission about the jokes that Mr. Ward had told. The Quebec Human Rights Tribunal then ordered Mr. Ward to pay money damages, and this damages award was upheld by the Quebec Court of Appeal. Ultimately, Mr. Ward was told to pay about $35,000 for these jokes. Now, this is where I take issue, and this is ultimately the issue that went to the Supreme Court, whether this penalty should be upheld. Like Mr. Ward's audience, I myself have laughed at some pretty rough and terrible jokes. I love comedy. Before the pandemic, I used to always buy tickets to a show in Toronto called the Just for Laughs 42 show, which is 42 stand-up shows across the city. And when I was in law school, I spent some time in New York for part of my law degree, and I lived right down the street from the Comedy Cellar, which is where some of the world's best stand-up comics go to test out new material. I even have tickets next month to go and see a stand-up comic perform in Toronto. So I really love comedy. In fact, if you have a favorite comedian, please put their name below. I'll check out their videos. I just love seeing new material. So because I love comedy so much, this case really spoke to me. It's really about whether the government can impose limits on comedy routines. And that is something I think is fascinating. The case went to the Supreme Court, and at the Canadian Constitution Foundation, we decided to intervene in support of the right to freedom of expression. Now, we didn't take any side about these jokes. We weren't trying to argue if the jokes were funny or if the jokes were cruel. Personally, as artistic expression, I think comedy isn't great when it punches down, to use Dave Chappelle's language. It shouldn't be about the powerful attacking and dragging the powerless. But this is a question for audiences, not for government. And in fact, the Dave Chappelle sort of brouhaha about his most recent routine on Netflix really shows how important this question is and why the Supreme Court's decision was so timely. So the very idea of dark humor, which is Mr. Ward's specialty, is to push the envelope, to find the barriers in society that leave audiences both laughing and simultaneously wondering if they should have laughed at all. The style of comedy involves observations about humanity and the things that people may have thought deep in the back of their head but have never actually said out loud. Louis C.K., another comedian, has a series of jokes that actually captures what dark humor is in a nutshell. He says, there's the good thing, the thing you believe, and then there's this other thing, which maybe you don't believe, but it's there. So in the normal world, when a comedian tells a rough joke that goes too far, it might bomb. And the consequence is that they don't tell that joke again. And if the audience does laugh at an especially rough joke, perhaps that reveals something about ourselves and about society. And that's in itself what the power of comedy is. Now, let's get to the result. At the Supreme Court, the court ultimately sided with Mr. Ward. He is no longer obligated for this financial penalty for the jokes that he told. And I think that comedians across the country probably had a collective sigh of relief when they saw this decision reported. There was some really serious concern that had the case gone the other way, there would have been a real chilling effect on all kinds of artistic expression, not just on comedy. The decision was 5-4, with the majority making some really important findings and observations about freedom of expression. The question at the core was really about competing rights, the right to freedom of expression and the Quebec Charter right to safeguard one's dignity and be free from discrimination. The majority at the Supreme Court held that the test for discrimination is not about the emotional harm suffered by the target. Instead, the test is on whether a distinction was made on the basis of a protected ground, in this case, disability, and whether a reasonable person would view the expression as inciting others to vilify them or detest their humanity, and would be likely to lead to discriminatory treatment. In this case, the court held that their test was not made out. The focus must be on the discriminatory effects of the expression, not on the emotional harm suffered by the person alleging discrimination. In fact, the court found that the tribunal was wrong for even letting it get this far, since they found Mr. Ward had decided to drag Mr. Gabriel not because of his disability, but rather because of his status as a celebrity, and that is not a protected ground. The court also made some really important statements about the right to freedom of expression. They noted that freedom of expression is meaningless until it requires us to tolerate what other people say, that it presupposes and fosters society's tolerance of expression that is unpopular, offensive, or even repugnant. Freedom to express only harmless and consensus opinion is not really freedom of expression at all, and I think that these are really crucial observations. The court also made some really interesting observations about their test and made some distinctions when it came to humor. They remarked that jokes generally don't encourage the denial of the target's humanity or their marginalization in the eyes of the majority, which is part of the test. If pushed to the limit, perhaps a joke could cross that line, but the court noted that this would only be in really extreme and exceptional circumstances. Second, the court noted that humor, whether in good or bad taste, in this case perhaps bad, but it rarely has a spillover effect needed to give rise to an attitude of hatred and discrimination among third parties. Humor involves really well-known methods like exaggeration, overgeneralization, provocation, distortion of reality, and the audience knows these methods. They know that they are at a comedy show. They know that jokes are jokes. Other than in truly exceptional cases, jokes would not have enough motivating force to lead to discriminatory treatment. So I think that this was a really excellent decision, and it was what we were arguing for. We argued at the Canadian Constitution Foundation that free expression creates an internal limit on other rights, like the Quebec Charter right to safeguard dignity, and we're pleased that the court actually adopted this as part of their test. The court held that when determining whether the differential treatment based on a prohibited ground impairs a claimant's right to full and equal recognition of his right to safeguard dignity, that right must be balanced against freedom of expression. And this is what we were arguing for, and it differs from the previous test, which only considered free expression at the justification stage and not at the discrimination stage. Now, one thing that sort of troubled me about this decision is how close it was. It was 5-4, and the test proposed by the dissenting 4 justices is frankly unworkable. The dissenting judges wrote that the right to safeguard dignity, which is protected by the Quebec Charter, protects individuals from speech that is, to use their words, so harmful that a reasonable person in their circumstances would refuse to tolerate it. It seems obvious to me that this test is just unworkable, since levels of tolerance vary pretty dramatically. The dissent would have seriously curtailed the right to free expression, including artistic expression, and this would have had repercussions well beyond Quebec and well beyond the comedy circuit. So I feel very grateful that while it was close, that isn't the case. And I'm also really grateful that we were able to play a role. But I'd really love to know what you think. Please leave your comments below and share your opinion of this particular case. All right, that's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.